Well, hello, everybody. Welcome again from the magic capital of the world in Colon, Michigan. I'm Debbie Davis, and I am going to go over just a few basic things about real estate transactions with deeds. So, a deed is basically a document. Oh, hold on. I'm going to have to fix that. I had it open so I could see the chats on the other side. So, hopefully, it doesn't get feedback anymore. Anyway, deeds, basically a piece of paper that is a legal document that gives the grantor and the grantee and their full name, address, marital status, that sort of thing, the legal description of the property. And here in Michigan, there's meets and bounds. There's, everything is pretty much platted, depending on what city or village or township you are in. And that legal description has a tax identification number that is unique to that specific parcel. And the first two numbers in it are your county designation, and then it goes down all the way to the latitude and longitudinal lines, so that if you get this legal description and the tax ID, you can find that parcel of property. So when you transfer property, there's a chain of title. So if you think about it, every piece of real estate that has a deed to it going way back is on file in the Register of Deeds. Sometimes it's called the Clerk of Deeds, but in ours, it's the St. Joseph County Register of Deeds at the courthouse. And at any given time, you can contact the Register of Deeds or go online. They have a program that you can pay a small amount and look up deeds by the name of the grantor or grantee. You can look up by the specific tax ID number, the address, and you can look at what transactions have happened on that particular chain of title for that particular property. The easiest way to do it is to have a title company do that search for you. That's literally what they do. So there are a couple of really good title companies in our county that we use when we do real estate transactions. And what they have is people that are well trained in finding every bit of information that is on that chain of title. So if it was your great grandma's property, but then she might have added one of her kids or grandkids to it with a quit claim deed, but then something else happened and then somebody had a judgment lien put against them or a builder's lien put against that property, they will find all of those liens and make sure that if you're purchasing that property, that you have a clear chain of title, meaning whoever is signing that deed is the rightful owner. There are no encumbrances. There are no easements that have not been described. And I mean, let's be honest, most properties have easements or shared driveways or that sort of thing. There's easements for public utilities. There's easements for neighboring properties. And these are the things you want to know before you pay good money for a piece of real estate. And even if the driveway looks like it's been there forever and it's well established, there could be lines that are off on your property boundaries. So paying for a survey, for a survey company to come out and put stakes in and find the markers that are in the road, the iron stakes, the pile of bricks and a wagon wheel that are referred to in some of the old deeds as their starting points, the surveyor can come out and do that. We actually had a situation with my husband and I. We purchased a piece of property, and it turns out the driveway was not where the parties thought that it was, and it nearly ended up in court, and it was not a pleasant situation. We did get it figured out, but turns out that the actual property line was kind of midway in this driveway, so we had to do some deed work to change that so that in the future, when we sold the property, that we had the proper meets and bounds and we had the proper description and that there's no issues for anybody else in the future. And it turns out that if you measured from the east point, it was one spot, and from the west point, it was another spot. So it was just a weird anomaly that happened, and 200 years or whatever, and nobody had discovered it. So glad we got that all straightened out. Now, with transfer property, there are really three different types of deeds that we typically would see. One is called a quit claim deed, not a quick claim deed, quit, Q-U-I-T. A quit claim deed is a deed that says whatever interest I have in the property, I'm giving it to so-and-so. Sometimes you would see people use quit claim deeds to add their children onto their property. Not the best idea in most cases, and I can kind of talk about that. But a quitclaim deed, generally, it's like, well, if there's a cloud on the title because of an easement or a judgment lien or taxes that are unpaid, you're just getting it. And whatever interest I had in the property, whatever liens there might be, you're now getting that property subject to those liens. So it can be a very dangerous way to take title to a property. We do use quitclaim deeds to fund a trust. So if you have a revocable trust agreement, you can use a quitclaim deed to sign off you and your spouse, whoever's interest in it, to that trust. And the trust then has an instant ownership in it. So quitclaim deeds are inexpensive. There is no tax certification fee to the county, which I mean is a very small amount. It was $1 for most of my practicing years. It now has moved up to $5, but still a very small amount to make sure that the taxes are up to date on that particular parcel before a deed is recorded. With quitclaim deeds, they don't check that, and you could be taking a property that is subject to a lot of back taxes, which is a very bad thing. Now, the second type that we typically see is a warranty deed. So a warranty deed is one that has a little more power to it as far as assurances that the person signing this deed is in fact the person who has the ability to do it. Generally with a warranty deed, if there was title insurance because they purchased the property and they got title insurance with the title company that says, hey, we looked at this chain of title, everything is good to go on it. The warranty deed can sometimes extend that title insurance out. Most of the time you have to get your own title insurance every time there's a new transaction though. So with a warranty deed, there is that $5 tax certification fee to the Register of Deeds. Again, that says that the county has looked and there are no back taxes owed on that particular parcel of property. Warranty deeds are what we typically use if you're buying property from an unrelated person or a related person for that matter. But if you are giving more consideration value than just like a love and other affection and $15, whatever, for quitclaim deeds. But you can put values on quitclaim deeds as well. So if you're purchasing like a lot or something and you don't want to go through the process of getting title insurance and you trust that, hey, everything is good, you're taking it subject to whatever liens there might be, you can do a quitclaim deed and put that $5, $10, $15,000 purchase price on there. And there are transfer taxes that are paid to the county and state with every real estate transaction. So it's a percentage of the state, percentage of the county, but there's those handy dandy charts that you can find online. As far as warranty deeds, again, those are the ones that we would typically use for real estate transactions when you're purchasing a house, like your house that you want to live in type of thing. The other deeds are Ladybird deeds. And I saw somebody like flipped over it in the chat about Ladybird deeds. Ladybird deeds are a type of warranty deed, but they're a specific type of warranty deed. They are written in Michigan law under Land Standard Title 9.3. And it's basically the idea that you as the grantor are reserving to yourself a life interest in that property, so that if you want to sell the property to somebody else, or you want to gift it to somebody, or you want to, if you have a mortgage on it and maybe you got to refinance it, or you own it free and clear, but you need cash and you get a mortgage on it, you can still do all of those things. And the grantee that is to get the property does not have an ownership interest in it until you have passed away. So in that interim period, if you decide, look, I am signing this Ladybird deed now in 2022, where my property is going to go to my 3 children in equal portions as joint tenants with full rights of survivorship, meaning if one of them were to die, their interest just disappears and it goes to the remaining 2 kids. Last to survive gets it all. If you do that now and then you decide 5 years from now, I don't think I want to leave it to my kids, you don't have to get their permission to undo that Ladybird deed that you did. You simply make a new Ladybird deed or a warranty deed or a quitclaim deed. But any deed that you do after that Ladybird deed, if you're deeding it to somebody else, it wipes out that Ladybird deed completely. So this is where I go back to, if you put your kids on your deed to your property with a quitclaim deed, the issue becomes that if your kids get into some sort of legal trouble, or they go through a divorce, or they have a bankruptcy or something like that, or they hit somebody with their car and they get sued, if they are a deeded owner via that quitclaim deed, or warranty deed for that matter, if they're an owner of that property with you, their creditors could attach to that property. So certainly not ideal. The other issue is if there is a falling out between you and the people that you have put on your deed, and it does happen even with kids, you can't just undo a quitclaim or a warranty deed. You have to have the signatures of your kids, and if you put their spouses on it, their spouses that have to sign off as well. So putting them on your deed in a quitclaim or a warranty deed manner is not generally recommended. Sometimes, though, if it's a matter of, hey, I'm passing this property down to them, they want to build on it, well, they have to have a deeded interest. They can't just use a Ladybird deed because the bank isn't going to loan them money to build the house that they want. So with Ladybird deeds, it's kind of like that best of both worlds where you can transfer that property to the people that you want it to go to, but you can also undo it if the unforeseen happens. If you are using a Ladybird deed, though, for an estate planning tool, and we always, generally, I always use a Ladybird deed to fund your trust, because that way, if you go to sell your property a few years down the road, you don't have to get a certificate of trust existence and authority drafted by an attorney and have that extra step of doing that paperwork. You still, because you own it as yourself or husband and wife, sign the buy-sell, you sign the deed to sell it, that sort of thing, without even involving your trust. However, if you were to go the Ladybird deed route, you really want to have a durable financial power of attorney in place. Reason being, there is that gray area of you being alive but incapacitated or unable to make financial decisions in your best most prudent interest. And if you have that durable financial power of attorney in place, your chosen person can actually execute a different deed or a mortgage or a refinance or a home equity line of credit, whatever it might be, to pull cash out of that home. And then when the deed transfer occurs, when you have deceased, your child or beneficiaries that you wanted to take that property, they're still going to get the property. It will be subject to any mortgage or home equity line of credit or any judgment lien that you might have against it. But in general, even if you were to take out your 80% loan to value that I think is the max that banks, mortgage companies will allow, there's still going to be that 20% of interest that is still available as equity. So it's unless the market totally crashes, there's going to be some equity in the house for your kids, even if you were to pull cash out of it. Some people pull the cash out of it just to invest it elsewhere, because if it's just sitting there, if your biggest asset is this home that is paid off completely, some people are under the theory that if they pull the cash out of that, pull the 80% that they can, using easy numbers, if your house is worth $100,000, you don't owe a mortgage or anything on it, a bank might loan you, if you got good credit, up to $80,000 that is backed up by that. So they take that whole $80,000 out. They then put it in a different type of investment, sometimes high risk, sometimes low risk, sometimes a mix. But then they are using that equity to their advantage while they can, knowing that, or hoping that, when the time comes and they pass away, worst case scenario, the kids are going to get this house and it's still going to have $75,000 owed on it, but they can still sell it for $100,000, hopefully more, and make a little money off of that. And they would still have that money that the owner invested, and hopefully that has grown. So definitely an estate planning tool that people use. With Ladybird deeds, because it is an enhanced life estate with a warranty deed, it does have that $5 tax certification fee. But again, a small amount to pay. But I have had clients where we got to the point of, okay, we're ready. Like, they've signed the deed, we're going to go record it. And the Register of Deeds kicks it back saying we can't record it because there's unpaid taxes. So you cannot use a warranty deed or a Ladybird deed if there are unpaid taxes. So that's one of the things to look out for. So I'm going to scroll back through and see if there are any messages that I think would be helpful to look at and answer. Thank you guys for being here. Roland, and is it Roland or Roland? I have an uncle Roland, but there are people that go by Roland, so hopefully I'm not saying that wrong. And Jane, Ian, Ryan, Robert Davis, Sister from another mister. Yes, I mean, somewhere down the line, right? Michelangelo from Australia. That's cool. Dennis from New Jersey. My friend Secret Squirrel. Jill, always nice to see you. Yes, happy Monday. Erdo, Gulpa Bill, nice to see you guys. Let's see, Ryan, you had to sign a quitclaim deed. Yes, and that does happen because the bank is looking at all of the deeded owners. So again, going back to putting your kids on your deed certainly can be a negative impact depending on what their own financial situation is. And obviously, I never recommend putting deeds in the name of anybody who's under 18 because then they can't sign anything. You'd have to get a conservatorship through the court and get court permission to do anything with that property if your child is on it. All right, Christina, yes, you had me. Ladybird deeds. Hopefully you got what you needed from that. Unclean hands, always nice to see you. Thanks for stopping by. Tom, do deeds have a price? Okay, so I mean, drafting of the deeds, the price that you pay to your attorney, okay, generally $100. Now, I say that in Michigan, but when I've done estate planning with people that have properties in other states, it can be $500-$600 for a deed, and then there's the recording fee. You are supposed to put the actual consideration amount on your deed. And that is what the tax assessor sometimes uses to help determine what the fair market value is. And if the taxes are uncapping and now there's going to be a different taxable basis for it, they look at, well, what was the market price? What did this place sell for? So when you do a deed, you have to do in Michigan a property transfer affidavit, which is this form that you fill out that tells the tax assessor what was the purchase price, what was the date, was it between related parties, was there a loan? If so, how much was the down payment? How much was the loan? Was it at market price? That sort of thing. So, and then again, when you have a deed that is for consideration, meaning I'm not just giving it again for love and affection and $1. If it's something where you sold the house for $200,000, there's going to be a transfer tax that is due at the time the deed is recorded, or they will not record it. That is a percentage of that purchase price. So, I mean, it can be anywhere from several $100s to several $1,000s, depending on how expensive that piece of real estate is. Okay, and then Suzanne, yeah. So there's also theories in Michigan specifically that if land has been openly, notoriously, continuously used for a period of 15 years or more, then you have now received title to that property. Again, it's hard to prove these sometimes. And I would say mostly around lakes, we see boundary line disputes. So if you want an adverse possession of a particular boundary line, then you have to have that open, notorious, continuous adverse use for a period of 15 years or more. And that can tack on from your prior inhabitants of that home. So a lot of times if somebody did put a chicken coop or a shed or their driveway on there, you certainly have that argument of adverse possession. There's also a legal theory of acquiescence. So if the person knew that you had done that and they never did anything to fix it or correct it, they may have acquiesced to your use of that, and you then get title to that. Also important with boundary lines, we do use quitclaim deeds to fix boundary lines. So if you, like in our driveway situation, find out that, oopsie, the driveway is, 3 feet on to the other person's property, you can then use a quitclaim deed to correct that boundary line. Okay, let's see. Ladybird deed is kind of like our slang term, I guess, for it in Michigan. Again, it's an enhanced life estate under Land Standard Title 9.3, which is specific to Michigan. But I do know from practicing in estate planning, when, again, we have snowbirds that go down to Florida and they maybe have property down there, there is something similar in a lot of other states. So definitely check into that. Yes, Ladybird deeds are a very good estate planning tool. And the reason why they're a great estate planning tool is because if it is something where your major asset is in this piece of real estate, if you can keep that asset out of any probate estate, you may be able to qualify for doing a very short form, inexpensive probate estate versus having a full blown probate estate where that piece of real estate is on your inventory and really drives up the cost. So in Michigan, there is, for small estates, a cost of living increase. I believe it's at around $23,000. I probably should check into that, 24 maybe by now. So if your probate assets are $24,000 or less, you can do the short form small estate, which again, you're talking only a couple $100 in cost to do that versus a full blown probate estate with a piece of property in it. You're generally talking $3,000 to $5,000 or more for a probate estate. So using that $100 deed, $35 recording fee with the tax certification for a Ladybird keeps that major asset out of probate and saves you a lot of money for your kids or beneficiaries who you're leaving to. Can one kid fight another if you have the Ladybird? I mean, there's always the chance that they're going to fight it, but if you have the Ladybird deed done by an attorney and it's signed obviously in front of a notary public and generally two witnesses and a notary public, and your deed is solid, those people can be called as witnesses to say that you knew what you were doing, it's what you wanted to do, and that there was no undue influence or duress or something like that. So they're pretty hard to fight so long as the grantor is of sound mind. All right, Kaylin should check out my video on estate planning in Michigan on my channel. You might actually like that one. I mean, it's kind of boring for some people, but it does give you some ideas of how estate planning and wills and trusts and that sort of thing work. Internet God, I know, R.I.P. to Schrodinger's cat. It's very sad, and I did not expect to hear that news when I got up this morning. So, Alexandre, from Montreal. Archo from Finland. It's Roland. Sorry, Roland. I mean, maybe my Uncle Roland has just said it wrong all these years. I mean, maybe. All right, Dax and Captain Cactus. Simon, something for the goats and the sheep. Oh, thank you. The babies are doing really well. Actually, my son, I picked him up from school. He's like, how are the babies? I'm like, they're so cute. So this morning, checked on them, got to get home. Now we've been at the office all day, but growing big. The one mama that lost her baby and had a really bad uterine prolapse, that's like a video and a picture for another day with a lot of warnings in front of it. She adopted one of the twins, like she was nursing off of her. So the vet was really happy about that. So it keeps her healthy and happy. And I haven't seen the vet bill yet, but I trust Alex to not overcharge me. And he did a really good job getting that prolapse taken care of for her. Poor thing. All right. Amanda, hello from Sydney. I really want to go to Australia, so hopefully we all stay in touch. And if I ever make it over there, you guys can tell me where I need to go. I really want to hold a koala bear. I know that's so, probably very touristy, but they just look so soft. Just want to pet them. Carrie, can you take someone's name off a deed? There are ways to get someone's name off a deed. The easiest way is have them sign off on it, right? They can sign a quitclaim deed back to you. However, I imagine you're saying, how can I get it off there if they don't want to take their name off? Well, that can be a little more tricky. There are actions for what we call partition, where if there is a piece of property that is owned by multiple parties and they can't agree what to do with it, which happens if you're talking like properties that are inherited from grandma and grandpa or mom and dad, and there's multiple kids on it and spouses of the kids, and everybody's got an opinion, right? You can do a partition action in the circuit court where you ask the judge to basically cut the property up and order that it be sold. It's not ideal by any means. And going back to deeds, there's different ways to hold title to it when you have more than one person. So if it's one person, they hold it in fee simple. That's just the person. They're the one person that owns it. If there's more than one, then it can either be joint tenants with full rights of survivorship, or it can be tenants in common, or it can be tenants by the entirety. Tenants by the entirety is reserved for only married couples. So if there's a legal marriage, you can own it as tenants by the entirety, which has the effect of if one of the spouses passes, the other just gets 100% of the property without having to do a probate estate. Just automatically goes to them. The only thing they have to do is record a certified copy of the death certificate in the Register of Deeds office in the county where that property is located. It clears the chain of title for that surviving spouse to sell or do whatever they want to do with it. Joint tenants with full rights of survivorship acts the same way, right? If there's 5 kids on it and 2 of the kids pass away, if the grantor has left it to 5 kids and grantor dies and those 5 kids are still there, they survived, but then before the property is sold or deeded any other way, 2 of them pass, then the remaining 3 kids keep title to the property, which is kind of rough because then it means if there were spouses or kids of the other 2, they don't get anything. So tenants in common means that everybody has an undivided interest in the property. So if there's 5 kids, they each have a 1/5 undivided interest in the property. And what that does is, okay, same situation. Grantor, mom leaves it to the 5 kids. Mom dies, 5 kids still survive. If something happens to 1 or 2 or 5 of the kids before they sell the property, then their 1/5 goes through their own probate estate. So it kind of follows the chain of their family tree. So tenants in common, a lot of times we will do joint tenants with full rights of survivorship from mom to the 5 kids. And then if mom passes and the 5 kids are still alive, we immediately turn around and have the 5 kids record mom's death certificate, but then the 5 kids do a deed to each other. So all 5 to the same 5 and make themselves tenants in common so that if God forbid something happens to one of them, their spouse or their kids would be able to take their 1/5 interest without it being absorbed by the 4 remaining kids. Hopefully that makes sense. All right. Do you need a survey each time the deed changes? No, you do not. And that's what gets people into trouble though, is if you're buying a piece of property and you didn't get a survey and the owner or the realtor is like, that's my property line right back there. See that shrub? It's like 4 feet past that or whatever. Even if there is one of these sticks that have the bright orange or pink marker on it, like, yeah, that's the survey stick. It could have been moved by somebody. So best, most prudent practice is to get a survey. However, they are very expensive. So I certainly see why people choose not to get them. But definitely there is a risk involved if you don't get a survey. Sometimes with mortgage companies, they will require you at least get a mortgage survey, which is kind of a lower cost option. But if they're loaning money to you to purchase this house, and if something goes sideways, they're going to have to take title to it. They want to make sure that they're loaning money on a legit, clean, clear title that they know is resellable, so that if they get stuck with that property, they can get their money back out of it. Okay, Stephen, thank you for the streaming. We need this distraction. Oh, I know. I mean, it's kind of boring. Talking about estate planning at this sort of time, probably. It's not ideal, but, it's better to get things planned while you still can. Okay, Ladybird deeds in New Jersey. Dennis, I don't know. I have not had any clients that are New Jersey residents, though I did have an attorney in New Jersey, so I guess maybe I do have a contact there, but definitely something that you should look into. Pro tip for tax purposes. No, Arto, don't do that. You're going to get yourself in trouble. Lauren, thank you for stopping in from Manitoba. Yeah, go Western Michigan University. So we have so many fun people that come out of that school. Tom challenged me, live an entire week having to title and deed everything you use. Oh gosh, that would be terrible. No, thank you. Okay. I think there's also sheriff's deeds, which are when you were to purchase a property out of foreclosure, you have the special deed that it takes it subject to the first owner's rights to redeem it. I don't really mess with those, but generally I think there's like a 6-month redemption period where the person who lost it to the foreclosure can come back and get it. But there's also trustees deeds, meaning that if you are the beneficiary of someone's trust, like a parent, grandparent, whatever it might be, and the trust owns that piece of real estate after the death of the original owner, the trust would then deed it to you. And there's a special language in it that protects the trustee, saying that they haven't done anything to damage the chain of title, that sort of thing, just kind of protects them. Same with personal representative deeds that are done when there's a probate estate. Okay, keep old pictures of your property. It does help. We have used old pictures sometimes. San Jose, born, yes, D-Town, Helpless Garage. Thanks for stopping in. Do I have a heater in the barn? I do have some heat lamps, but they make me very nervous because I had a problem with a heat lamp a few years ago that was really bad. So, yes, we do have some heat sources there. Okay. Hi, Jay Hamilton from Scotland. Okay. Yes, Amanda, take me on a tour. That would be fun. You guys in your different time zones. It's crazy. Okay, well, guys, I think I might have covered all of the super chats and the questions. Let's see. Speaking of joint tenants, one lives as a primary residence, the other left voluntarily. Is there a way to fight a partition? You know, there's always the argument of unjust enrichment, meaning like, hey, I've been here paying the taxes and the utilities and the maintenance and the upkeep on this for 5 years, and you guys have done nothing. But that can be kind of sticky. So you got to get a judge that understands where you're coming from with your formulas. But looking at, okay, if you were to have paid rent to those other 4 people that own it, say that the going rent for that particular property is like $1,200 a month, well, you would be paying that $1,200 into a bank account. You would then be a 1/5 owner of that bank account, but then also taking into account the taxes that you've paid that they should have been paying 4/5 of, and kind of down the line, and any maintenance that you had to do. That's really the only way that I've seen to kind of control those issues of joint tenants that have a legal interest but aren't chipping in. And that's where, if you do inherit some sort of a piece of property that is like a vacation home or a cottage or whatever, I generally have people do some sort of a cottage use agreement. So there's not any dispute as to who's paying for what, who's using it when, and it protects everybody involved. And it gives you a way to buy the others out if there's a problem. Oh, geez. Let's see, 9:47 a.m. Oh, it's so late. Well, Amanda, if you come to the States, you come visit. You should come during Magic Week, though. It's like the first weekend in August. It's fun times. People let them, like, they rent houses, like their rooms in their houses or their houses completely. And because we don't really have hotels in Colon. So super fun time to be in the Magic Capital. You will see some magicians that are truly world-class. So if anybody's coming in the summer, you plan that around Magic Week. And if you call Abbott Magic, they can try to hook you up with somewhere to stay. I can't say my house because I got a bunch of kids and goats, and I tell you, it's always something. Okay. Can you sue a person for internet slander or defamation? I mean, that's a tough one because you have to prove, 1, that it's not truthful, 2, that you had actual damages, and that's where defamation and slander being spoken, libel being written, you have to prove damages. So even though somebody is being truly horrific to you, if you can't prove some sort of monetary damages, it's been my experience that the court doesn't do much to enforce it, which is really sad. I don't practice in civil law, though, so there's my disclaimer. But definitely talk to somebody who practices in civil law if you think you have a claim. better to get good, competent legal advice than to never do anything and lose your chance or miss your statute of limitations. Yes, landlord tenant, always something interesting going on there with Judge Middleton. So, okay, everybody. Well, I truly appreciate everybody coming, and thank you for the super chats. It was very sweet of you guys. If we have any questions, I guess you can drop them in the comments. If you have ideas for live streams or things that you want to know more about, drop it in the comments. If you could like and subscribe, maybe share this. Hopefully, even though it is Michigan-based information, it can have some nuggets of information that can be used in other jurisdictions too. So you guys have a wonderful night. I'm going to try to not freeze and go visit the baby lambs. So, thank you.